Okay, we should see the people start rolling in here in a minute or so. There they are. Give it a few seconds so people can join in here. And we'll go ahead and introduce everybody. Okay, and then people will just keep rolling in. But in the meantime, let's go ahead and get introduced. Hello, everybody, and welcome to the cyber law panel tonight. We've got some amazing people that you're all going to learn a lot from. I'm hoping to learn a lot too, especially about topics I don't know that much about. Does everyone want to introduce themselves?
Sure, ladies first. I'm Jessica Gross. I work at a private law firm in downtown San Diego called Shepherd Mullen, Richter and Hampton, and probably 5 other names, but just Shepherd Mullen mostly. We're, I'm sure, going to hopefully keep you entertained, but also possibly bore you with all of the things that we do in cyber law from the outside firm perspective. And I will pass it to, I graduated from UCSD in 2017. I was at Eleanor Roosevelt College, really had a great time there, and I'm very glad to be back and talking to you all. And I'll pass it to Arsen since he's kind of a similar deal as me.
Thanks, Jessica. My name is Arsen Karinyan, and I'm a data privacy attorney at a private law firm also called Perkins Coie. I hold the various alphabet soup of credentials for data privacy certification through the International Association of Privacy Professionals. And I basically advise clients on how to comply with the different domestic and international data privacy laws. And I'm happy to join this event and to introduce you guys to data privacy and cybersecurity law.
And my name is Brendan McHugh. I'm a deputy district attorney with the San Diego County District Attorney's Office, and I'm the project director for a high-tech crime task force called CATCH. My responsibility is to investigate and prosecute high-tech crime, and in that role, I also basically manage our forensic lab doing digital forensics. Also a graduate of UCSD.
All right, so we got some awesome panelists, some from UCSD, some from outside, but more perspectives, all the better. So, but UCSD is the best, just so you know. So, toss it out there. But let's go ahead and get started. I'm going to have you guys and attendees, if you would like to submit questions, just send it to the little question window, and then we'll kind of, interrupt here and there, and we'll ask your questions. In the meantime, though, I'll just get us started. So, do you all want to take a second to describe your role and how you got the job that you are in now? I guess, Jessica, you can start us off again if you'd like.
Sure. I'm also probably the newest, so that might make most sense. So at UCSD, I majored in sociocultural anthropology because I couldn't do the math for psychology. No. I thought it was a really interesting undergrad, and I remember not really sure if I was going to go into a PhD or what for graduate school, because everybody knows you can't just have a bachelor's in anthropology. It's not a thing. So I was looking at different options, and I had always been really intrigued by the human condition and the way people choose to live their lives and the things that are important to them or how to maybe control them. And that is very intimately tied to data privacy and cybersecurity from a legal perspective in particular. So at law school, it's, a lot of testing or a lot of teaching to help you pass the test, which is the bar exam. So mostly based on kind of core legal, contracts, property law, wills and trusts, right? Kind of like your general ed, if you will. There are some rare opportunities, I think, to learn about cybersecurity and data privacy while you're in undergrad or in grad school or law school. So I tried to take every single one of those that came my way. What really got me intrigued was I was doing a moot court competition that was staged in front of the International Court of Justice, and it was like North Korea plus the United States were spying on people, and this guy, Edward Frost, found all these suspicious surveillance programs and leaked it. And then all of a sudden, computers mysteriously began blowing up in other countries, and they said it was us, but no one could prove it. So I got really interested in this, like cyber warfare, geopolitics, espionage part of cybersecurity. But to be successful, I had to kind of understand how networking worked and hacking worked, because that's how I argued that it wasn't us, right? Because I knew about attributions and vulnerabilities, et cetera. And that, I think, made me realize that the internet is everything, right? Like our lives are digital, everything about us is digital, which really linked back into kind of that anthropology core for me of, you know, this is how human existence is now. And we associate ourselves in all of these different, you know, online platforms and draw a lot of meaning and cultural symbols from this, and, you know, for better, for worse, right? And also, of course, I'm here to stop Skynet. This is my life goal. Okay, next.
Yeah, I guess I'll go next in the order. I went to undergrad at UC Santa Barbara, I guess San Diego's cousin. And then when I went to law school, this was a little bit over 10 years ago, there actually wasn't a much courses or any information about data privacy. I think at the time, as Jessica mentioned, when you go to law school, your first year is sort of like your general ed, where you take some general courses about legal concepts and things of that sort. And privacy sort of came into play when we learned about doctrines from like the 1800s about, there's a famous professor named Professor Prosser who had the 4 torts of privacy. And it really dealt with like these common ideas going back to, you know, several hundred years of don't invade someone's privacy, don't go into somebody's house, or don't disclose private information about somebody to the public. But the modern idea of what is cybersecurity and data privacy, I think it really developed quickly in Europe, way further than the US was even involved in data privacy. And then we really started to see data privacy develop in the US, I want to say maybe a couple of years ago, to be honest. Otherwise, data privacy issues were mostly coming up in different sectors of society. So the way I got introduced to it is after I graduated, you know, I was mostly doing litigation at the time, but every little thing I dealt with different industries, they had like a little tiny bit of data privacy laws involved in it. Like sometimes I would deal with healthcare issues, and there's a law called HIPAA that dealt with healthcare privacy and security. And then in the financial sector, there's various alphabet soup of laws, and some of them have some privacy issues involved in it. But then, you know, in 2016, Europe passed this major data privacy law called the GDPR. And then in the US, California passed this law about 2 years ago and went into effect actually last year. And that's really when it took off. And I think now it's great because young professionals like yourselves who are studying in school, you can actually start in this area of law as it's developing. And it's really exciting. And I find it very, I really enjoy this area of law because it's the new frontier. We're dealing with advances in technology and artificial intelligence in these different tools that are coming up in startups with social media, machine learning, and the ad tech industry as well, which gathers our data and uses it to target ads to us online, which you may have noticed if you go on Amazon and you look for shoes and suddenly you're on random websites and you're getting ads for shoes. And so it's an exciting area of law. And I think it's great that you guys are interested in this because it's really developing. And if you do go to law school and decide to pursue that route, I've heard a lot of law schools now are offering cybersecurity and privacy courses as fundamental courses that are available in specializations, which is great. And so you guys are definitely thinking about these issues at a good time.
All right. And then Brendan?
So I was born at a very early age. And from there, I have been struggling to grow up ever since. And so for everybody who's having trouble with that, you're in my, I understand you. So I didn't come about my position directly. I actually went into the military and did electronic warfare for 6 years on board a surface fleet. And when I came back, ended up going back to school and actually was at UCSD studying philosophy. And the joke with all my engineering friends, because I was working in engineering at the time, they would ask me or tell me that I'm going to need to learn the phrase "Do you want fries with that?" because that was going to be my future life with a philosophy degree. So it turns out that actually philosophy and in particular epistemology and logic were very helpful in bar prep in understanding arguments. When I went to law school, I was still working in engineering. I worked in engineering as an associate engineer and as an engineering tech when I started for about 10 years, and then decided that engineering really wasn't for me. I wasn't finding any purpose in it. So when I went to law school, I initially was looking at going into patent law. And one of the things I did that I would really encourage all of you to do is to spend some time either volunteering or doing internships in the areas in which you want to go into before you do, so that you don't spend 10 years in a career and realize, I hate this job. And so I was working for a federal judge, clerking for a federal judge while I was at UCSD. And no, I'm sorry, yeah, UCSD, just going into law school. And he told me, I don't think you're going to like patent law because it's not going to be that different from what you're doing. So why don't you look at criminal law? And once I did that, everything changed. I interned for the DA's office here in San Diego for a year and just found myself in a place that I really fit, doing things that I feel matter and have meaning to me. My particular unit was formed back in 2000. There are 5 of us across the state, 5 task forces like mine. I've been the director since 2009. But one of the things that is different in the stateside prosecution route from going into civil firms is that there's not a direct path to tech, to my spot. So you really first have to go through all of the sort of beginning prosecutor stages of dealing with DUIs, with sort of misdemeanor offenses, graduating into felony offenses, and getting a broad sort of background and experience in prosecuting cases before you can go into a niche such as what I've gone into with high-tech crime. But there are paths to it. You just have to put in time ahead of time, becoming sort of a generalist in order to get to a position where you're dealing with very specialized area.
All right, awesome. So as you guys can see, it's a variety of different backgrounds, how they got to where they are. I think everyone here had an amazing journey that we can all get a lot of experience from and learn a lot about. So I think to kind of get started, what do you guys do in your day to day? What's it like in your shoes for a day? I guess, and this time to kind of mix it up a little bit, let's start with Arson this time.
Great. Yeah, thanks. That's a good question. I think, just to echo what Brendan said, if you're interested in this area, you should volunteer. You're probably, in your undergrad, you might not do like extremely substantive work, but just simply being in an office where you're with the attorneys who are doing that area of law, you'll see what their day-to-day life is, because it's very radically different than TV shows. Our life is not like the TV show Suits, or any of those TV or in those movies you see. It's really, so my job in particular, and again, I think if you volunteer, you'll get to see in the different areas of law what people do. But a lot of my job is advising clients. So what I'm on is often I'm on a lot of conference calls. I have clients in different countries, different jurisdictions. So my hours vary. Like tomorrow I have a call at 2 a.m. because we have to talk to attorneys in Germany and UK. That's just how the time zones work. But I'm mostly on the phone all day, to be honest. I talk to a lot of people. Pre-COVID, I was visiting people in person. I was doing some investigative work as well related to identity theft. And so I was traveling a lot. I was at one point at the airport every 3 weeks, heading off to some different location where I was meeting people, interviewing them, talking to them about their issues. So that's a lot of my job, is advising them. And I think a lot of my clients, I would say a lot of the issues I deal with, it's like solving a puzzle, which is really different than other areas of law where you mostly have arguments, you prepare them, and you argue them either in a brief or during an oral argument or trial. Mine is like, my clients have discrete questions that they want to have answers to, or they have a scenario where they plan on launching a product or a service, and you sort of have to solve that puzzle of, okay, how do we do it so that it complies with these private sector sort of areas of law, data privacy laws. And sometimes it's very difficult to solve that puzzle because there is no global data privacy law. Rather, every country has its own, well, not every country, but most countries have their own sort of unique data privacy law. In the US, you have different states with different data breach notification laws, in addition to California, and then Virginia just passed this extensive data privacy law. And we're seeing a little patchwork of data privacy laws spring up in different states. And so it's taking all these laws and some of them might be inconsistent, some of them might have different requirements, and trying to give a pragmatic solution to a client where it's like, hey, here's how you do this, and here's how you can approach it in a way where you solve the problem for different issues and different laws that apply. And so it's really exciting because oftentimes I'm in the seat of seeing new product launches that haven't hit the market yet. They're in their very early stages. We sometimes review schematics to see how the data is going to flow for privacy by design issues, to make sure that privacy rights and issues are protected as the data flows through the system for various products. So that's really my day-to-day job. A lot of it, like I said, is advising, talking to people on the phone, now through video, and then hopefully once COVID clears up, in person.
Awesome. And let's go ahead, let's popcorn to Brendan.
So my day-to-day is really along a spectrum of what is happening in a particular case. So one of the roles that I fill is that I advise outside law enforcement agencies on issues in their high-tech investigations. So you might have a small agency that doesn't really have people experienced in investigating high-tech investigations. And so they'll come to me or to my team, and then we'll sit down and talk about the progress of their investigation and then ways to advance that investigation, whether it be through search warrants to third-party providers, or chasing down other investigative leads, and ultimately to forensics on the devices that we seize from the suspect's location. That's one part of it, sort of the advisory role in assisting law enforcement with their investigations. And then the second part of that is during the course of the investigation, primarily with my team, but also with outside agencies, I review a lot of search warrants. Definitely, if you're going to go into this area, you want to be an avid reader and a good writer, because you'll be doing a lot of both. And so I read a lot of search warrants to ensure that there's probable cause to justify the seizure of the items that are being sought. And then once those search warrants are served, then I'll go back into that advisory role again and talk about what follow-up investigation from the information obtained from the search warrants are. Once the investigation is complete and we've identified the suspect, then I transition into the role of prosecution. And there I look to make sure that the case is provable beyond a reasonable doubt before I can issue it. And then once I issue it, basically I'm working on, I will write briefs for legal issues to explain, for instance, why this piece of evidence is admissible, explaining the theory of the entire case when we're going into the trial stage. Up to the trial stage, there are a number of hearings that have to be prepared for, such as suppression hearings, where the defense wants to contest a search or seizure, and then preliminary hearings where a judge will hear the evidence or a portion of the evidence to determine whether there's probable cause that the person charged committed that crime. And so we have to prepare for that hearing, prepare the witnesses, and then conduct that hearing. Then there'll be another series of sort of litigation steps where I'll need to prepare additional motions in preparation for a trial. And then, of course, trial is sort of the culmination of this whole thing, where we'll bring in witnesses and evidence to prove the whole case. And that involves going back to the investigators and talking them through what they did and why, and understanding everything beyond just what's written in the written reports, so that you can really present it in a way that a jury of 12 people who their sole qualification is that they had a driver's license or they bought property, and they showed up to jury duty. And so, a lot of time is spent, particularly in these technology cases, in working with the technology experts, the detectives, so that they can explain concepts like IP address tracing to your grandparents who are sitting in the jury box, and that's sort of the character of my day, depending on where a case is in that process.
All right, awesome. And then last but not least, Jessica.
So I actually wanted to do cybercrime, but then I had a lot of student loans and it doesn't really work out so well. So I'm in the law firm for now. We'll see if life changes for me, but you'll have to also excuse me. My dog is throwing a tantrum in the background here and I'm trying to throw him toys, but so I do a lot of advice and counsel like Arson, I guess. So I'll try and highlight some different things. Without question, I think the puzzle metaphor is like very apt. I always call it grasping for straws. Like you're just like, let me use these totally either underdeveloped legal concepts or like 1930s legal concepts to try and solve a problem that's a real world problem that like lawmakers did not really think about. So I'm not going to get on a soapbox here, but very quickly, because I don't think people always think about this as a career opportunity. But influencing legislation or being part of legislation, being consulted in the legislative process is a little bit of what we do. So we'll have big clients who might be really impacted by a specific privacy law. And they'll say, oh, we don't like this, we do like this. And so they'll put some efforts towards submitting comments, submitting letters and things like that. So that legislators whose only qualification, let's say, probably were graduates from college, if that, decide or make up a law that takes into account the technology, the changes that will come, and the practical implications for business and consumers. Because I think right now we're ending up having to explain a lot of these laws to companies. Companies are spending tons of money trying to understand, how should I retain data? How should I secure data? What should my privacy policy look like? But then it ends up with these kinds of results that aren't necessarily helpful to consumers. So helping read between the lines is a lot of what I would say I do too, because I don't know, I'll stay off that soapbox. I think one of the most fun parts of the day-to-day is the emerging technologies like Arson's talking about. Being involved in, like right now, huge is NFTs and this artwork that's related to blockchain technologies, and you can get an original, one-of-a-kind minted tokenized artwork, and there will be some intrinsic value in that. And there's some really cool artists coming out and really cool clients who have like online galleries. So I've been getting to do a lot in the blockchain space and on the crypto side as well, cryptocurrency side. I'm on the blockchain fintech team at our firm as well. So that can be really interesting because I think it's, I guess, kind of back to what I was first saying. You're in a place where there's no law, like no direct applicable law, but you realize that there should be, like there should be some, restraints on pumping and dumping schemes for cryptocurrency, even if it's not truly a security regulated by the Securities and Exchange Commission, right? Or, the IRS wants to tax it, but they don't want to call it a currency. So a lot of my day to day is putting together the puzzle, grasping the straws to try and make something that is legal but reasonable and functional and will last, you know, so that they don't have to keep paying you $100,000 a year for this. That it can be really challenging. I think you, in addition to reading and writing, you have to be a real out of the box thinker and not afraid to, I don't want to say not afraid to fail, right? But not afraid to probe into the unreasonable to find a better spot, because a lot of clients want to go into the unreasonable.
All right, awesome. It's great to hear about all your day-to-days. They're all just like, even if you're in like the same field, it's all a little bit different. Even though you're all lawyers, you deal with different things. That's really awesome to hear. So I guess let's kind of start getting into the nitty gritty of it. We do have a question from the audience, but I'm actually gonna go a little bit more broad first, and then we'll jump into their question. Do privacy laws apply to both government and commercial organizations? And would you say is it the same? Is it a little different? Like how would you all say that works?
I could chime in on that. I mean, the thing is, there is no sort of overarching data privacy law. Rather, there's different laws that apply in different situations. So there are, in fact, laws that relate to government agencies, and Brendan probably knows all about that. On my end, we deal with data privacy laws that are in the private sector, that deal with private companies. And actually, the way those laws are written, it specifically states that it applies to, let's say, businesses that make certain revenues and do certain types of business and collect certain types of data related to people. And so there are different types of laws on that. So really it depends on what you do and what area of law, what industry you're in. There could be different areas of law that govern that industry as well, that are like sectorial laws. So it really varies from government to private, and then also from sectors, different sectors of society, and what they do and what the company does in that sector.
Anybody else have anything else that I could put on that?
I would just say that in terms of like the breach notifications and things like that, those do apply both to government and to public and private sector entities. The prosecution of California privacy law stuff typically falls to the Attorney General's office with the way the statute was written. But you know, in my role, I'm looking more at crimes rather than I would consider data privacy, you know, sort of data breach type stuff to be more of a neglect issue or a negligence issue. I'm looking more at willful, you know, attacks or you know, deliberate act.
Knowing.
Yeah.
So, and that's actually a great point you bring up. You bring up things like GDPR, which is the European, and then in California, there's the CCPA. And of course, there's other things like HIPAA, for example, which are the healthcare privacy sort of laws. How would you say that sort of ties in a little bit with your roles? Like, do you have to think about that when you're maybe writing up legal documentation or when you're going into litigations and things like that? Is that something you have to consider a lot of time?
Yeah, definitely. I mean, oftentimes, you know, sometimes you represent clients and it touches on a whole host of those laws. And so whenever a new matter comes in where it's like it's a new client and they have all these data privacy questions, before I even get into like what product they're getting into, I need to know about that company. And so we start off with questions like, okay, what geographic region do you operate in? So that'll inform me of, is the CCPA applicable, which is California's data privacy law? Are you operating in Europe? Do you do business there? Do you target people there? Do you have an office there? Then the EU's GDPR may apply. But then it's like peeling a layer of onions. The more you peel, the more laws you discover that apply. Because they might not have an office in South Korea, but they might send data there, or data from South Korea comes into the company in Europe, or they might have a vendor there that does like payment processing or certain consulting services. And so you really have to start off by asking all those questions to really know where they operate. And then you go to the next level of asking the questions of what types of data are you collecting? So for example, if I'm dealing with a financial institution, the Gramm-Leach-Bliley Act might apply because they're, let's say, collecting certain financial information or account information. And then if I have a client who might not be like a doctor, for example, but let's say they developed a machine that's an insulin pump for people with diabetes, and all they do is provide a remote connected device that pumps insulin into someone, then it may touch on some quasi HIPAA issues where when they're drafting a contract with the doctors who might use it, they have to include certain terms in those contracts. And so it really goes to having conversations with clients about all those issues. And it takes some experience to really think through all those issues of what could potentially apply. Initially seems daunting, where it's like, oh, there's like these millions of laws, like how do you find out which one applies? But then once you start asking these basic questions and really thinking through and working with a strong team of other professionals, you start to unravel that onion, the layers of onions, and you figure out which laws apply in this scenario.
And for me, questions of jurisdiction in terms of different laws that apply will come up in that, in cybercrime, oftentimes our bad actors are not co-located with, where the victim is, right? So we'll have a bad actor out of, Eastern Europe, for instance, and they're outside of our jurisdictional reach. And in order to effect sort of, further develop the investigation, we'll have to engage law enforcement in the foreign jurisdiction. And so we'll have to see that the law that was broken in the United States, the crime that was committed here, is also a crime in the foreign jurisdiction, so that they can effect legal process to advance the investigation. As an example on that, we had a case that we turned over to the Irish authorities for prosecution because they could prosecute it in Ireland, but the information that they had access to, they couldn't release to us under their regulations. So that's kind of where we navigate these complexities.
And then Jessica, I saw you unmuted. Did you also want to throw something in there?
I totally lost sound for a second, so I'm not sure if you covered it. I have to call back in. I was going to say, there was a question about substantive due process or the constitutional right to privacy. Did we go there already?
We have not. I was actually going to go there next, but feel free to be the first to answer. Well,
I think it kind of clarifies why there's all these different laws, or helps to clarify, maybe not fully. So this is, generally speaking, the federal constitution, right? The US Constitution does not itself contain an explicit right to privacy. There's Fourth Amendment, which I'll leave to Brendan, which is really just more about being free from certain types of government intrusions. And I think people think about it as privacy, but that only applies to the government, right? So to the extent you have a company, a private company is not governed by the Fourth Amendment. They might be governed by the 14th, which is where substantive due process comes into play, and that there's been Supreme Court cases that have, read from the penumbra of rights in the Constitution that, yeah, human beings have this right to privacy. So that's the federal background. The states, like California, Article 1.1 of California's Constitution is a inalienable right to privacy, which includes in personal information. Now that laws will kind of explain that, right? Other states have this too. So when there's a federal law, the Health Insurance Portability and Accountability Act, HIPAA. It's really related, or it came about to make insurance and Medicare processing better, and then also to make interoperability of electronic records. And then once they realized, hey, there's a little bit of danger here, okay, let's add some security and other like contractual and notice requirements. But that was really kind of like It doesn't apply to just any healthcare entity. It doesn't apply because it's medical information. It really is just involved in this kind of health insurance space. It's not really like a privacy like we think, right? Law. Same with the Gramm-Leach-Bliley Act. That's really about financial institutions. And yes, it has ways that you can limit certain sharing of your information with other like non-affiliated banks or something. Or it has like requirements on security again, because hey, if you lose all your bank account data or if people are accessing certain sensitive information, it has a problem. And that's not good, right? So those are really more like industry regulation to regulate certain conduct of the entities. They're not necessarily focusing on like, what does the consumer right here? Like, what's the consumer control? California being, you know, one of the most consumer friendly states, with one of the first states to have the constitutional right to privacy, has been really big in this space. Maybe also because we invented the internet, you know, whatever you want to say. But there's a little bit more in California, or like in the EU. There's a Universal Declaration of Human Rights, which gives you a right to privacy as a human right. And so that has influenced the European experience, and taking it from the perspective of the human right as opposed to some kind of like industry regulation, which do also exist out there. So that's kind of like where the constitutional rights come into play. And that, you know, Law 101 is really because lawmakers are only given certain amounts of authority. So the Constitution sets kind of a floor. Then there might be a regulation that delegates authority out to somebody else, right? And it's all tied, though, to some original constitutional authority, legal authority. And then you end up with a mess because they don't talk to each other or think about it.
Yeah, and just to add on to that, I think the history of a country has a lot to do with how these laws develop. So, for example, in the backdrop of how the U.S. Constitution was developed with the Fourth Amendment, for example, and the amendment related to quartering of soldiers, the biggest concern to citizens there during the Revolution was that this tyrant government was literally storming into our house and coming into our house and directly intruding into our physical sense of privacy. And it's interesting how the Fourth Amendment developed, where we went to an actual physical entry of premises, to things like the Katz decision, where it talks about telephone intrusion. And then now with the Jones decision about GPS devices on a vehicle, of how it's now this this concept where our forefathers thought of and had the vision to think of, that could address all of these issues, because it's a fundamental right not to be intruded on your physical right to privacy. Now backtrack with a backdrop in Europe of how the European law developed. We're dealing with post-World War II. The Stasi in East Germany were essentially monitoring their citizens and doing mass surveillance, and technology at that time was a lot more developed. And so with that backdrop and the European Union forming, they realized that there could be grave violations of human rights if this particular form of privacy, where it's not a physical intrusion, but the systematic monitoring of people outside of a physical presence or location, is a problem. And so that's why when Europe's data privacy laws were developed, it was essentially not a concept from 300 years ago or 200 years ago. Rather, it was something in the immediate post-World War II world, where technology was rapidly developing. And so it's an interesting history of how things develop, but and it sort of explains why Europe, at least in the modern iteration of privacy, is so far advanced than the US in this area. In fact, it's interesting, the US is such a superior country and a dominant power in the world, but Europe actually considers the US to be inadequate to even receive the data of their residents. And there was like a major decision that came down recently in Europe called the Schrems II decision, where they essentially said, wait a minute, you can't even send data to the US. I mean, there's a lot of caveats to it, but in a simple term of you can't even send it because the US government is surveilling on all of our data that's crossing through transatlantic cables to the US. And part of that reason for that is because we don't have a federal nationwide privacy law that will address some of these concerns that Europe has, for example, with sending their data to the US. So with that backdrop, I hope that you find that helpful of how these laws develop.
See, study anthropology. It's totally a cultural response. It's totally true.
And to understand the landscape of legislation in my space, the Federal Electronic Communications Privacy Act, which essentially categorized different types of information, whether at rest or in motion, and the level of legal process required in order to obtain it, was enacted in 1986. And it was last changed in 1986. So that is still the federal law governing what, what the containers, the types of information are, and a legal process in order to access them. Now, after the Riley case, which had to do with the warrantless search of cell phones incident to arrest, the Supreme Court found this expectation of privacy in the data contained on cell phones, different from a trespass theory that had been, that was a more historical one. But then in Jones and the GPS decision, they also talked about the trespass theory, saying we didn't give up that. We're saying that there are these two, broad areas. So California, then after the Riley decision, enacted the California ECPA. And this was, I think, 2016, when it was enacted, maybe 2017, I think 2016. And it advanced.
Yeah, it was amended when I was working with you, so I think 2016.
Yeah. So it's been amended even since it was passed, unlike the federal ECPA, which 18 USC I don't think has been touched. And so the California ECPA then sought to create a process and requirements in terms of how we treat stored electronic information, whether it be on a device or a third-party provider. So it's the legislation in this area is interesting because it really lags tremendously the technology. And if you look at the Supreme Court decisions, when we talk about Olmstead or Katz, those are some of the first decisions dealing with phones. But the first phone was 1850. So we're not right on the bubble in terms of law and technology.
That's interesting to hear, especially since all of you sort of agree, it seems like, on the same things, in particular that the US maybe is a little behind in the privacy world compared to our European brethren, or even California as its own thing. So, and there was a second question in chat, and I'll ask it. It's a little bit more of a specific one. So, what's the current legal understanding with the impact of US versus Jones in respect to data privacy and criminal prosecution? And I'll let anybody who may know the answer to that or has an understanding of that answer that.
So Jones is an extension. So what the issue in Jones boiled down to was the federal agents put a tracker on a vehicle. So when you obtain a search warrant, you have a certain amount of time. In California, it's 10 days. And in this particular event, it also was 10 days. And the warrant was obtained in District of Columbia. The GPS device was attached to the vehicle in Virginia, I believe, on the 11th day. And so it went to the Supreme Court about whether this warrantless tracking of a vehicle was allowed under the Fourth Amendment. And there are a series of cases about if you're traveling in a vehicle, there's no expectation of privacy because you're in public. But when that tracking sort of extends to a place that we reasonably expect to be private, and there's an objective belief in that sort of privacy, that the Fourth Amendment applies. And in the Jones case, they moved away from the idea, they didn't move away from, but they made the distinction that this was a physical trespass on property, which was, if you go back to the language of the Fourth Amendment, that's what it's talking about, is a physical trespass. the reasonable expectation of privacy standard that has guided Fourth Amendment jurisprudence really came out of Judge Brandeis's dissent back in 1920s about this reasonable expectation of privacy. And so that's really the body of Fourth Amendment jurisprudence sort of developing in Jones. So in Jones, the Supreme Court said it's no different from when the Constitution was first enacted. If you trespass on property without a search warrant, then you violated the Fourth Amendment. But the other issue with Riley, with Carpenter, so Riley had to do with the cell phones I was talking about earlier, the search incident to arrest without a search warrant. And then Carpenter had to do with third-party records that were cell site location information data. So they obtained the location information of the cell phone subscriber without a warrant because that can be obtained under the federal ECPA under 18 USC with a subpoena. And so the question there was, is there a reasonable expectation of privacy in this information that is held by a third party? And the doctrine up till then had always been, well, no, because it was disclosed to a third party. But what the Supreme Court discussed in the Carpenter decision was that this is not just ordinary information. This is specific location information that goes into details that you can't get with ordinary surveillance. And so advancing the logic in Riley, they said, because of the nature of this information, this digital information about us, there is this reasonable expectation of privacy and falls within the Fourth Amendment's protection. And so a search warrant is required. But that's sort of where the Fourth Amendment is today. It's a more expansive understanding of the Fourth Amendment than just the language that has developed over all this time. Slowly.
All right. Awesome explanation. I hope our student got the answer they wanted. I thought it was very thorough. I thought a lot of information. Awesome. So let's go ahead and we're going to kind of circle back around now. If we've kind of gone to a lot of the technical details of specific laws and jurisdiction, what would you say are the most challenging parts of your job? And then maybe also the most interesting. We'll do like a half and half, like I guess a challenging and then an interesting one. And then let's have Arsen give us a start.
Yeah, thanks. So I think the most challenging issue is this area of law is, as Brendan mentioned, the law is far behind in advances in technology. So oftentimes you're dealing with issues of first impression and there is no law to address it, or the law that exists is not adequate to address it. And so I'll give you an example. Several years ago, I was doing a slew of cases involving theft of cryptocurrency. And in this scenario, what would happen was a hacker would get access to your cell phone through call forwarding or SIM swapping. And then they would use that for two-factor authentication to get into your Coinbase account in order to deplete your cryptocurrency from that was stored in the Coinbase account. And so when the lawsuits started to come in, at the time the price of crypto was fluctuating. At the time of the theft, the price of, for example, one Ethereum, for example, was like $15 or $5. It was very low price. I mean, by the way, now it's like over 1,000. And the price at the time the lawsuit was filed was actually at the time around the end of 2017, over $1,000. And then actually 2018, around 20, end of 2017, beginning of 2018. And so this issue came up, okay, I can argue the substance of the case until the cows come home, but really fundamentally, let's get down to the brass tacks, which is how much money can we lose if we lose this case? And what are the damages if the plaintiff wins? And there is no case law on how to value cryptocurrency. Like, do you value it at the time of the theft? Or do you value it at the time of the lawsuit was filed, or at the time you get judgment in your favor? And so you really have to dig back, and I actually found some law related to theft of artwork from the early 1900s, where maybe when you steal the artwork at the time, it's not worth much, but then the artist dies, and then suddenly it's worth millions of dollars. and how do you value it? And there's some common law doctrines and old case law where it said it's from the date of the theft, because it's way too speculative about what the price would be in the future. And so using these old antiquated concepts, we came out with an argument, and we were able to do some strong defense to that case as far as how do you value the cryptocurrency and to not get a bad result, for example. So I would say that's the challenging thing, is like, how do you think of creative ways to address these problems when the technology and these issues are rapidly developing while the law is a bit stagnant? I would say the most interesting thing about what I do is dealing with new technology. I'm really interested in technology, and it's great when you're representing really huge corporations, that well-known brand names that you might have heard of, in new innovative products that they're launching, and you're sort of sitting front row and center on all of these issues, and you get to help them build that product, at least the privacy aspect in my case. So I would say that's the most fun part. And also, what Jessica touched on is part of our job also involves shaping the legislation. So, with California, for example, with the data privacy law coming out, when it first passed and there was a draft of the law, I was intimately involved in learning all the nuances that was going to going on and helping clients with the regulations that are being drafted in various iterations that are coming out. And even now with California, there's a new law going into effect called the CPRA in 2023. We're very actively involved in seeing, okay, what regulations are going to come out here, what are issues that are problematic, and what do we need to address to help innovation and products. And so it's really fun to be in that new frontier of technology and law at the same time.
I'll go. I think this was actually my question, and I don't actually have an answer, but I think the challenge is the interesting part, actually, because I would say the challenge is, dear God, you work a lot as an attorney, but let's not talk about those negative things, especially in a law firm. Well, and I'm sure, Brendan, like when you're in trial, or there's certain times like you are just busy. I can see how tired I was, but the challenging parts, the interesting parts, right? So all the things Arson's talking about, Brendan's talking about, right? These cutting edge laws, cutting edge technologies, huge problems, no solutions. That I think can be very, very cool to work on and to gain access or insights to things before they're coming out, or help kind of mold the directions that things might go in. I would say in a specific, because there is no, well, as far as we know publicly, there isn't any true AI, like I would say. But some of the cool stuff I think I've been working on lately is helping training algorithms. So like, there's a lot of bias, right? They call this like bias in AI, like bias in algorithms, because sorry if I offend anybody, some like 40-year-old white dude or 30-year-old white dude made something and decided these were like the points to hit and these are the correlations to make. And if you get this right combo, like here's the outcome, right? And it came up for us where the client wanted to do some sorting of renters, because there's a lot of issues with evicting people. There's a lot of issues getting rent. So they wanted to kind of get like one more layer in addition to the background check that you already have to do, right? When you go to rent an apartment or something. They wanted to know more about you, right? They wanted to have profiles, risk profiles, and income speculation, and things that we were interested about, right? But when you rent, there is this law called the Fair and Equal Housing Act. It essentially comes out of the 14th Amendment, and your right to be free from racial discrimination, national origin, religion, right? So if you have an AI or if you have an algorithm, let's call it this, that's trained to look at like certain income points and family sizes or whatever, maybe you're not even trying to be racist and exclude a certain type, but it can have an impact, right? It can bend a certain way just because of the data points you decided to choose as the data points for X outcome. And I mean, you guys are all smart and in this field. I had totally took for granted that computers were objective and you had inputs and outputs and that was it. And now that I've been getting into this, I'm like, oh my goodness. And and we're creating these things. Like, so it's always going to be limited by certain human factors. And I don't know, maybe that's the anthropologist me again. So interesting what those factors are, and then the outcomes. Last thing I'll say on that is the case in point, facial recognition software has been like notorious for this. That if it can, like, with X, 90 something, 80 something % accuracy, it'll get every white male right. But you put a black female and it's like 50-50, or you put an Asian female and it's like 20-30, like, because it's just not trained by people with discerning eyes, or it's made by someone that thinks they understand what points to look at, that those points are inherently shaded by their own perception. So I love that right now.
For me, I'd say similarly, the interesting part is also the hard part, and that's really looking at technology for a way to solve, who did this, how do I find them? As we transition into IoT and, where everything around us is a data collection point, it presents interesting stuff for us when we're looking to prove a particular person was in a particular place and committed a crime. And so that's both the interesting and hard part, because, we're dealing with encryption, and that's always a challenge that is difficult, but again, interesting. And then just the mass data that is available, it's astonishing. We have to, when we write a search warrant based on probable cause, we have to justify each piece of information that we're seeking from, the third-party provider. But understanding, for instance, what it is that Google collects based on your ad ID, that I might be able to write a search warrant for. Staying on top of that type of stuff is a challenge, but again, it's probably the most interesting part of it, because it's just an insight into the world we live in, to understand how much data there is about us out there.
Awesome. So many different, like, really interesting things, so many different challenging aspects. It's kind of funny. You really never think about it in those ways. Then we hear you all bring it up. It's like, that's really cool. Never thought about it that way. It's never been in that field, never worked in it. It's kind of like, that's really interesting though. So I guess this is our last real question tonight, and then I'll have one more after this as we're tying up here. But what do you think are some areas of cyber law that will change, or maybe even be created? What do you see as I know Jessica brought up like the facial recognition type thing. That's kind of a really interesting one to hear about. But what do you all think is something you're like, that's gonna be really interesting when it finally comes to the forefront of things?
You know what I'm going to say. Regulation of AI. Go ahead. You can top it off. It's going to happen way too late. I'll be there. You might be too. It might take like 10 or 15 years.
Yeah, in my opinion, I think changing the law based on just developments and technologies is probably a bad approach, because you're always going to play catch up. I think what we need to see is a nationwide federal comprehensive data privacy law that is tied to certain fundamental principles and rights, so that it could apply across the board. And then obviously later there might be some piecemeal laws like facial recognition and biometric laws that every state develops. But I think until the US, for example, has a federal law that covers across all 50 states, I think we're always going to play catch up.
I agree, and I think there may be an inevitability that we're always going to be playing catch up, because I just think that the creative process behind technology is dramatically different from, and I'm loosely saying creative process of legislation. I'll just leave my comment at that. So yeah, I agree.
Awesome. And then last question tonight, we have mostly, I want to say almost all students in this room, and they're all hungry for knowledge. That some of them maybe even like, this is really cool. I may want to go into that field, that privacy field, that whole area of law. If you were, I want you to look at yourself today. Go back in time, you see yourself as a student. What would you tell yourself to do, knowing all that you know now? For all the students that are here right now, looking to learn.
Yeah, I mean, I would say, talk to a lot of people in different areas of law, just to learn, sort of like what you're doing now, attending this event, just to learn what they do on a day-to-day basis. Because again, when you read about something and just see something on TV, or maybe take a course on something, you actually might find the course interesting, but in real life, you might not find it that interesting. So it requires a lot of like deep searching to see what characteristics of a job you like, and then maybe just go try it out. Go shadow somebody for a day, maybe once COVID clears, and really get a sense of what their day-to-day life is. And don't just rely on, again, what you read about or what you see on TV, because it's a permanent life, well, almost a permanent life decision you make when you go to law school, become an attorney, or any other field you pick. And just going back in my life, I would have thought it would be good to just go back and shadow a person who's an attorney or a cyber warfare specialist or whatever it might be, just to get a perspective of what their day-to-day life is. And I think that'll be very helpful in informing a career decision.
Yeah, I would echo that, because I know you can see I'm tired. No, I think like it does take a certain type of person, and there are many ways to be involved in this field besides just law. Like, we intimately work with forensic examiners or testifying experts, or people work in companies developing the products, right? So you can get into this field a lot of different ways. And maybe the law is for you. Maybe this is the way for you to go, and it does fit, the kind of lifestyle you want, the amount of sleep, what you expect and what makes you happy. And I would say, when you are trying things, because you absolutely have to try things, talk to people, like Arson's saying, and like Brendan said, go try and get internships. Try it out, and then pay attention and be honest with yourself about your feelings. It is a lot of money, a lot of time to commit if you're not, like, even when you want to hate the job, if you don't still like the job, you should be thinking about other ways to go, because life is precious and your job is amazing, but it shouldn't be the only thing in your life, I hope. So don't just think like, oh, lawyer and this and that. Like, there's a lot of cool things to do in cybersecurity or privacy. And it could be an outside firm, inside firm, or as a lawyer in a company. There's a lot of different avenues. So be open and adaptive.
And I agree. I go back to what I said in the beginning. Definitely volunteer, intern, get exposure to the workplace. So the same thing my colleagues have talked about. Understand what it is before you go into it. But then the second thing is, as you heard, I didn't come directly to where I am. Don't be afraid of that. If you go down this road and you get into something where you feel like this isn't doing it for me, this is a broad enough area that you can find a lot of other places to land. So don't feel like I want to be in this particular space and that's the only place I can go, because I'm proof that you can wander the earth and just bump into good opportunities.
All right, awesome. Thank you so much for this amazing panel. I learned a lot, far more than honestly I've ever known about the law, but I'm happy that I know it now. It's really cool. And I hope all the students that are in this panel also learned a lot. Thank you so much for all your knowledge, your insight, your experiences. Couldn't get it anywhere else. Just so unique. And for the students that are here, we are going to have a little bit of a breakout room thing after. So if you do want to meet, there are two different clubs here, actually, ACM Cyber, and we have the Law Group Review at UCSD. So feel free to hang around after. You can meet some of your fellow students from different clubs, Law and Cyber. Kind of cool. So, but once again, thank you so much to our panelists for all the knowledge and experience that you brought to the table tonight. I hope you enjoyed it too.
Everyone have a great evening. We really appreciate